Today we're discussing whether healthcare acquisitions should be structured as asset sales or stock sales. From a practical perspective, whether the sale of medical and allied health practices are best structured as asset sales or stock sales largely depends on the goals of both the buyer and the seller, as well as the legal and regulatory landscape in the particular state. I'm a Georgia-based attorney speaking about general legal principles today. You absolutely need to connect with an attorney licensed in your state and familiar with the specific laws and regulations applicable to your circumstances in order to get legal advice. Let's begin by briefly reviewing the fundamental differences between an asset sale and an equity sale in the context of healthcare M&A specifically. In an asset sale, the buyer purchases specific assets such as equipment, contracts, office space leases, and intellectual property from the selling entity. The buyer does not assume all liabilities or obligations of the selling entity unless specifically agreed to. This allows the buyer to cherry pick the assets that they want and avoid undesirable liabilities. Buyers like this because it gives them more control over which assets and liabilities they take on, making it easier to exclude unwanted risks or liabilities. But in an asset sale, the parties must go through a number of additional regulatory hurdles, such as obtaining consent to assign insurance contracts, securing reapprovals from Medicare and Medicaid, and complying with licensure or accreditation requirements. In states like Georgia, an asset sale triggers a cumbersome change in ownership process, whereas certain stock sale transactions may only trigger the administratively less burdensome change in information requirements. In an equity sale, in contrast, the buyer purchases the equity, whether shares of corporate stock or LLC membership interests, of the entity. In this video, I'm using stock sale as a blanket term for any equity sale. In these transactions, the entire business, including its assets, liabilities, and contracts, continues to exist as it did before the sale, with only the ownership of the entity changing hands. As I just alluded to, stock sales generally avoid many of the regulatory and compliance obligations that are triggered by asset sales, such as change in ownership applications or having to obtain consent for many, although not all, contract assignments. But a stock sale means that the buyer will inherit all of the seller's liabilities, including legal, regulatory, or operational risks that might not be immediately visible. As a result, stock sales can be riskier for buyers if legal counsel does not incorporate thoughtful indemnification provisions, including purchase price adjustments, indemnification escrows and holdback amounts, and other ways to hedge against the risk of non-recovery for undisclosed liabilities in the event that the seller becomes insolvent. Because of the apparent advantages to buyers of an asset sale, more often than not, offer letters and term sheets start from this assumption. That may well be sensible, particularly if the acquiring party is a private equity firm or a larger entity that does these deals all the time and has a systematized way of managing regulatory obligations. But I do want to emphasize, especially for smaller healthcare buyers and sellers who are operating at the local city or county scale and for whom this deal is a one-off transaction, that asset sales may trigger burdensome additional obligations. In Georgia, healthcare entities, especially those dealing with Medicare and Medicaid, must file a change in ownership or a CHOW application in the event of an asset sale. This reapplication process can be time-consuming and may lead to temporary disruptions in operations. Further, any agreements with insurance providers, managed care organizations, or other third-party payers would require consent to assign these contracts to the buyer in an asset sale. You need to look at the specific terms of your payer contracts, regardless of whether it's an asset sale or a stock sale, because even stock sales may require advance notice to the payer, sometimes 120 days or more in advance. But with asset sales in particular, in some cases, payers may use these as an opportunity to renegotiate terms, adding complexity to the process. This is especially true when a payer contract has particularly favorable legacy terms that have sort of floated under the radar for many years. There are a couple ways in which payers can use this situation as an opportunity to amend out or otherwise eliminate favorable payment terms, which can have a material negative impact on the business's profitability. To be very clear, this dynamic is different when private equity is involved and they are purchasing multiple related regional practices to achieve economies of scale. They have more leverage over the payers in a way that is quite rare in practitioner to practitioner and other local market sales. And finally, asset sales might also require that the buyer obtain new business licenses or accreditations depending on how local laws classify a change in ownership for a healthcare entity. In contrast, a stock sale allows the entity to continue operating without triggering these reapplication and consent obligations. This can be advantageous if the practice relies heavily on insurance contracts, payer relationships, and state or federal program participation like Medicaid or Medicare that would be burdensome to renegotiate or reapply for. Private equity firms and other buyers that are consolidating practices and rolling them into a larger mega entity often still opt for asset sales despite the additional regulatory obligations for several reasons. First, control over liabilities. When consolidating practices, private equity firms and other experienced buyers generally prefer to avoid acquiring liabilities from the selling entity. In an asset sale, they can take only the assets that they want, such as equipment, patient lists, intellectual property, and contracts, and exclude potential liabilities, such as pending lawsuits or regulatory violations. This helps reduce the risk for the buyer, especially when acquiring multiple smaller practices and then rolling them up into a larger group. But note, if you are doing a stock sale, there are various ways to hedge against this risk, such as comprehensive indemnification provisions and an escrowed indemnification reserve account, wherein money is withheld from the purchase price and can be clawed back by the buyer in the event an indemnifiable claim relating to these or other latent risks is later made. Second, tax considerations. From a tax perspective, asset sales can sometimes be more favorable to the buyer because they may allow the buyer to step up the tax basis of the acquired assets, resulting in potential depreciation and tax benefits post-acquisition. If you have CPAs involved in the transaction, and you should, you may find that they zero in on this issue specifically, sometimes at the expense of any other relevant legal or practical considerations, and will categorically advise buyers against anything other than an asset sale. For large transactions with well-staffed entities who do this type of transaction all the time, their point is well taken. But for smaller clinics and buyers, please consider that the additional regulatory hurdles and costs of compliance associated with a one-off sale can ultimately outweigh the tax advantages around a stepped-up tax basis. This is why personally tailored advice is essential. Third, integration and streamlining. So as I alluded to previously, in a roll-up strategy, private equity firms may consolidate multiple small practices to create a more efficient and scalable operation. In these cases, asset sales allow the private equity firm to integrate the practice into its existing infrastructure more easily. By acquiring only the assets, the buyer can move existing contracts, employees, and equipment into a larger consolidated entity while avoiding the liabilities or contracts that may not fit into the new structure. Of course, for one-off sales from small buyers who don't have this existing infrastructure in place, the calculus shifts, and the buyer may prefer to acquire the existing entity as a whole via stock sale and make incremental improvements through the structures that are already in place. For the seller, an asset sale could still make sense if they are willing to deal with the regulatory and contractual reassignments, especially if the buyer offers a higher valuation to account for these burdens or has the willingness and ability to assist the seller with the process. Just be sure to engage independent legal counsel as well as financial and tax advisors early on in the process so that you aren't so blinded by the purchase price dollar signs that you lose sight of the pre- and post-closing effort that will be involved. In Georgia and in many other states, private equity firms often favor asset sales when consolidating multiple practices into a larger, more scalable entity despite additional regulatory hurdles. However, in physician-to-physician transactions, where the parties are looking to avoid reapplications and preserve payer contracts, stock sales may offer an easier path forward. A lot of transactions fall somewhere in between, with a buyer that isn't quite as sophisticated and experienced as a private equity firm that scoops up healthcare practices as its principal business, and a seller that may be willing and able to deal with some additional regulatory and payer contract burdens as long as the price is right. This leaves a lot of room for negotiation. And please be sure to see my earlier video on the corporate practice of medicine doctrine and management services organizations as it applies to healthcare M&A transactions. When the buyer is not a licensed physician, this also has a material implication on how the transaction must be structured, and also on how the clinic will need to be run on a go-forward basis. As always, each transaction should be evaluated on a case-by-case basis.